Wait a few minutes just for me to get acquainted.
Yeah.
Okay, so welcome everybody. Thank you for being with us with this for this second talk of the Geneva Rights and Environment talks. Sorry, on the side of this 61st session of the Human Rights Council. Very happy to greet everybody in the room and online. And today we are going to focus on quite an important issue, although it might sound a bit technical, which is the question of impact assessment. And I'm purposely not just saying environmental impact assessment, because we'll see that it needs a larger scope, but at least the question of impact assessment. And if we're focusing on this today, it's because the UN Special Rapporteur on the right to a healthy and sustainable environment, Astrid Puentes, who is with us today, presented her report on this issue to the United Nations General Assembly last October. And of course, as it's happened in New York, the fact is what happens in New York stays in New York, and that's precisely what we're trying to avoid. And it's quite important to enlarge the discussion on such an issue. So we're very happy to have with us first, as I said, the Special Rapporteur, who will start this discussion, but then it will be followed by a number of expert analysis or consideration in order to feed our discussions. Coming from those who know very well the international system, but also we're very, very happy to have the opportunity to hear how this is happening on the ground, particularly in India. But I'll present the speakers as they will be given the floor. So let's start first by having this first introduction on this report that was presented at the UN General Assembly last October on the question of impact assessments, and started basically with the title of the environmental impact assessments. So thank you very much, Astrid Puentes, for being with us and for having done this work on this issue, which is so often one of the problems we face and one of the very first problems we face when we're dealing with environmental issues. And so what are the recommendations? How was it fed by the different issues that we're facing throughout the planet? And also what was how was it received when you were in New York? So thank you again for being with us, and the floor is yours.
Thank you. Thank you very much for organizing this also. Well, welcome. We're just starting, so you're welcome. And thank you, very much. Yes, please. Space and not chairs, but so I really appreciate also the Geneva Environment Network and all the work that you're doing and the support, Harvey, Diana, and others that are behind the scenes, and of course Eve and other organizations that help this side event to happen. And the key things, as you mentioned, but I want to repeat it, is that we need to make sure that what happens in New York doesn't stay in New York, and that hopefully human rights conversations and the mandates work also continue and strengthen and continue being presented in New York. One of the challenges that I've seen, and it includes for environmental impact assessments, is that we live still in a very compartmentalized world where the environment, the legislation, the institutions are in one planet, and human rights are in Geneva, and the negotiations on climate or biodiversity are as if they're other planets. And of course, we know that we live in one single planet. So the reason that I wanted to do this report is there's several reasons. One of the main recommendations and suggestions that I'm doing is that we change from talking also only about environmental impact assessments to talking about EIAs, which is a little bit of a riddle. But the idea there is to talk about environment for states to do environmental, social, and human rights impact assessments. Mm-hmm. The first thing to say there is that I'm not trying to replace or start over in like the due diligence human right that state companies, for example, have to do on human rights and environment. That's a separate thing, right? And that remains the same. But if there's going to be a new activity or a project that is specifically going to be licensed, then this process should also include social and human rights as a same integral perspective. And the other reason, what I hope that this report will be useful, is that it integrates the advisory opinions. The ITLOS one was published a few months before this. The ICJ one was published while I was editing. So that's why you might feel that it's hooks of the ICJ one. And that's exactly why, because it was right there. But I thought that it was very important to include those references because we need to use the advisory opinions. They are absolutely key and redefining. The critical failures or the challenges that I saw, we also did about 6 different consultations in all regions. I talked with, and thank you, by the way, for your input and participating in the consultations. We did one here in Geneva. And I also had conversations with businesses. And it was very interesting for me to hear overall the same challenges or failures, conflict of interest. Everyone. Of course, as you can imagine, indigenous peoples, people in the ground, organizations, UN entities, and also businesses for them and the government. That was one thing, that people that is committed in environmental authorities, they see a conflict of interest as a huge challenge because they have the lobbying really on their neck. And a conflict of interest is something that is preventing good evaluations, good capacity building. I heard someone saying that a concern of some would be was the revolving door. And there are other people will say there's not even a revolving door anymore, which is horrible. Exactly. They don't even mind to put a revolving door, right? And so that is something that and maybe I'm not saying to you things that are that you didn't say. The failure to prioritize prevention and really do a good assessment, which of course is, I mean, if we had a good assessments, then maybe some regulations can go over or advance because we knew that in the assessment process, then good decisions will be made. But it's as if when project is being requested for a license, it's kind of automatically that they will have it, which is not something that we should see. And fossil fuels, it's not only fossil fuels, but fossil fuels is definitely one key aspect. And the fact that there's check the box approaches, right? Like this, yes, we're doing this as a procedural and it's just like literally checking the box. And in that sense, and as you probably saw in the report, I also tried to incorporate key decisions from courts. There are many. But at least the ones that I found that was key, linking environmental impact assessments with human rights. So of course, the decision on the Norwegian case in the European Court of Justice was very relevant and also new. But the fact that the court is saying that doing an EIA and a proper EIA is a human rights issue, and it's an obligation for states, was of course very useful. Fragmentation of projects is something that I've seen for decades, and I think that that's a key aspect to continue advancing, and hopefully the report will help. Arbitrary accepting sectors and projects, and we see this with renewable projects in Europe and the directive and the regulations for solar and wind. We are seeing also with gas projects because they are natural gas and very renewable, emergent. So that is something that I highlighted as a problem. And of course, something that is against international law and human rights. Once an assessment is licensed, the monitoring and compliance of that is also, sometimes there's some structure for the assessment, but once a project is approved, then there's pretty much either none monitoring. And I think that that's a good also perspective to think from our work, both as mandate holders and organizations, to follow up that. The weakening of the rule of law, and this is something that I guess that I will be insisting and stubbornly, but it's a huge problem for in EIAs, again, as you know, the EU regulations, but also many countries. I included a list there. It's not exhaustive, and unfortunately, Angola, Brazil, the US, Honduras, Indonesia, Peru, the UK, Serbia, Uganda. And that is something that for some, I've been trying to follow up with communication. So if there's other things, considering resources, but I would like to follow up on this because the states need to see that it's not only, of course, the theory, but in practice, that can be a big ISDS. And I just saw the time, so I will go faster. But investor state dispute settlement. So as you also know, and that is something that I would love to be able to, in coordination with you, or to follow up, because as you know, my predecessor did a report on ISDS, and we have talked about this, and it's specifically about EIA, environmental impact assessments, or ESHRAs, environmental, social, human rights impact assessments. And speaking with governments, there is a concern there, whether they do a good environmental impact assessment, and then if they deny the license, then they will subject to ISDS. That's a concern, that there is both conflict of interest, but the possibility of being sued, which is true, as we saw and we have seen, which is a problem. So I think that, and I would love to follow up this with states that are open to have that conversation. And neglecting procedural rights. I mean, yes, the check links to other things. The checklist for FPIC, pre-prior informed consent, the checklist for information, it's in the website. Sometimes it's not in the website, sometimes it's impossible to find in a website. So that is something that, of course, implementation. I'm not going to go in detail with the obligations, but as you could see, what I tried to do is summarize and strengthen and clarify the obligations of the states on environmental impact assessments, again, using the advisory opinions. The ICJ also, before, the ICJ has a lot of jurisprudence already saying that states have to undertake environmental impact assessments. Transboundary issues was a key aspect, and I think that I hope that it will continue. And I tried to do this, of course, with a lot of help from colleagues that are experts on communications. So to make sure, and this is the framework that I'm offering, to make sure that ESHRs are, prior to the decisions, are comprehensive, observe environmental principles, so precautionary principle, prevention, proportionality, best available science, maximum disclosure, equity, and non-discrimination. Be truly independent, which is a huge, as I mentioned, problem. Ensure access to information, actually ensure that, and public participation, access to justice and effective remedies, and special measures for marginalized communities. And I'm proposing in that sense, and I would love to hear what you think, a framework for how to do it, because in a lot of situations, governments are saying, well, I don't know how to do it, or the regulations. I'm like, well, there's a lot of information. So the idea there is to have like an ABC on how to do it. And I guess then you mentioned the recommendations. So the main one is that states must regulate environmental impact assessments for all projects, including for climate action or solutions, and make sure this is considered. One thing that I heard a lot is in the process to analyze alternatives and no project, or the zero alternative, or the zero project. So include it there. And I listed, and this is not comprehensive, but I listed projects or activities that must include ESHRs. All fossil fuel, including exploration and extraction, definitely should include that, but also industrial agriculture and industrial fishing, which is something that I addressed in other report, wastewater, metal, or like all metal, metallurgic, cement, fossil fuel related projects should have this. So I'll stop just saying that there was a lot of appetite and interest. And one of the things that I would love to happen, hopefully, is that I saw also that UNEP, UNDP, UNICEF, like UN institutions also have a lot of information and regulations, the World Bank as well. They don't talk as much or strong enough on human rights. So that was also the intention of doing this, to make sure that they incorporate the human rights perspective, the right to a healthy environment, but also other human rights. So thank you very much for this space.
Thank you to you, Special Rapporteur, for this very comprehensive presentation of your report and the issue at stake. I guess that when you're saying that there is a need to include more human rights aspect in some of the existing impact assessments, which are already compulsory, I'm sure this resonates very strongly to you, Sandra. And so here in Geneva, we have our own ICJ, but here the ICJ is the International Commission of Jurists.
Exactly the other one.
But we have
So
a website.
you're right. So it's the other one, but precisely, Sandra, you're leading the international advocacy work of the International Commission of Jurists. I know the Commission and yourself, in your personal capacity as an expert in this field, has worked on this question of impact assessments, and I've heard you more than once insist on the linkages needed between the two fields. So again, I'm sure this has really resonated, and we're looking forward to hear your contribution in this discussion.
Thank you so much, Yves, and thank you to the organizers, Jen in particular, for creating this space. And as you understood from Yves' introduction, it's a very important conversation for me and in general for human rights. So thank you for having me with you. And as you have understood, it's a bit of one of my favorite issues, not to say an obsession of mine, or it became an obsession of mine because I worked on the 3 continents for more than 25 years now, and on different projects, and that have huge impacts, obviously, on human rights, including the right to a clean, healthy, and sustainable environment. And for which I had to be confronted with environmental impact assessments as documents, as processes, etc., and where I saw all the gaps and the issues that have been highlighted by the special rapporteur just before me. Environmental impact assessment, and I will use EIA as a shortcut for the discussion, but I really take the point very seriously that the special rapporteur just made, not entering the issue of definition of name, but of course we are talking sometimes about slightly different processes and documents, especially because now with the work on due diligence laws for businesses, but also with the ongoing negotiations for a future treaty on transnational corporations and other business enterprises, we see a lot of movement in that field to ask for systematic human rights impact assessments, etc. So again, this is a much more complex issue than just that, but in the interest of time and the simplification of our discussion here, I will just use EIA in my presentation. But it's really in a way the first key procedural step that allows such projects, as I was mentioning, the ones I had to deal with, to start and to continue. And I will focus on these kind of impact assessment and not so much, so really at the level of projects, more than the ones that are also supposed to be carried out, as was alluded to, and I'm sure my colleague Caroline will come to the broader ones that really are when we are to develop new laws, big policies, or enter big trade agreements, for instance, also at a more meta level in a way. So I will stick to the project level in my reflection. And what I will highlight now, all the aspects or the points that I will make are mostly captured by in the written input that we sent to under the call for inputs that you had in the preparation of your report that you mentioned, and that was presented at the UN General Assembly. So it's online and can be accessed. It's from April 2025. So as I said, EIAs have been the procedural step and aspect through which affected individuals and communities have typically been supposedly consulted and participated in decision-making process, but also have tried to access justice, because it's one of the first interface that we have as lawyers, jurists, accompanying communities to try to to stop a project or to try to address some of the features that we will see in any kind of rehabilitation, reparation, or compensation schemes that will come afterwards. So it's much beyond the purely technical aspect of the project itself. It's obviously in human rights terms very important for the right to remedy and reparation. And EIAs have traditionally, so I started to work on some of these issues back in the 90s, and we were seeing, so a bit of a historical recap, we saw, and I think it will speak to Caroline's expertise as well, because we come from the same perspective or background on that. We saw a lot of these discussion very much influenced by the way big international or intergovernmental organizations were acting in the field, and in particular the IFIs, the international finance institutions, and not to say the least the World Bank. So there was a massive influence of the World Bank on mining codes, on this kind of documents and policies and laws at the national level. Not the least in African countries, whereby the whole setting or framework to deal with, let's say, the communication in a way with communities that would be affected by any kind of development and investment projects would be handled. So this was massively changed by these new mining codes that would leave to private actors, the investors basically, to handle all of this. And so they would also be in charge of the impact assessments, or like to prepare the ground, let's say. And that has changed massively. And so it's interesting for me because it's not revolving door, but it's like a movement of history that tries to bring us back to more role for the state in that context. Because as we heard, if you leave it to one company with the community to handle all of this, then you lose the decision-making and policy-making space of the state that is there, very critically needed to make sure that international human rights law obligations are adhered to and complied with in this setting, in terms of procedural aspects, but also in terms of substantive aspects. So digression, but I think as in all of this, with this kind of evolution or development in mind, we've been identifying a lot of issues with this kind of almost first step, because also at the and I think it's still the case in many instances, the EIA, and that's why I think you're calling to rename it and include social impact assessment. And even if we are supposed also to have human rights impact assessment nowadays, I think the EIAs are still the place, or a major place, where what is supposed to be social aspects or social concerns are scattered, like are taken care of. And basically what this means is human rights. So human rights have been put into environmental impact assessments as social concerns. So dealing with compensation for communities, looking at who would be affected, compensation for harvest would be lost, land will be taken, etc., etc. So it's interesting because we see that EIAs have been also the place where human rights impact assessment de facto have been done, and the problem for me in very concrete terms was that it meant that sometimes not the most adequate and legitimate and well-equipped authorities would have to be dealing with these issues, because we had to, the EIAs most of the time go to environmental authorities or at the Ministry of Natural Resources, mining, whatever it is, but not people who are supposed to have either an eye for and an expertise on these so-called social aspects of it, which are de facto human rights issues. But now, with the recognition of the right to a clean, healthy, and sustainable environment globally, or at the global level, as a universal human right, of course, this has to change, and that's, I think, one opportunity that we have to harness. And I think the report is a very good step towards this. So we have a lot of issues in the substance of what is captured in EIA. Oftentimes it's done in a rather rushed manner, not always with the right expertise. It's very complex issues most of the time. And I think I will just give one example, and this is the one that just is a manifestation of my obsession. Is the one of in Colombia that I worked with in more details, and it was about Colombia, not under the current administration, but an older project that is called El Quimbo, which is an hydroelectrical, it's a dam project on the Rio Magdalena. And this is, for me, an example for the book of everything that can go wrong with an environmental impact assessment. So it was for us very, very difficult to access the documents as the lawyers of the communities affected. Then we discovered that it was such a document. I'm showing it for the people online as well, but it's really like thousands or 2,000 pages. I mean, it's such a document that none of the authorities with the existing capacity would really master anyway. So you skim through it, but this is really not like what will be very determining to really know the kind of impact. We also discovered that key scientific evidence was completely missed because, of course, no one would turn to the local universities and the biologists, for instance, in terms of biodiversity expertise, or the sociologists or the anthropologists, etc., who would deal with and know the communities they have to consider. None of this was really taken into consideration because these very big consulting firms have been playing a key role, and the conflict of interest and capture is obviously a key issue here and in general. But it was very clear that there was no proper local process and consultation, and then very key and fundamental knowledge and scientific evidence and indigenous knowledge was missing in the whole assessment, and that led to complete wrong conclusions and assessment of the risks and the loss in biodiversity, among other things. And then even in the middle of it, very well hidden in maybe at page 600 something, we discovered that there was the name of the place was not changed. So basically it was a blueprint that was reused, and the villages sometimes are just exchangeable, whether you are in the Sahel or in the middle of the Amazon. Well, I'm exaggerating because this is too obviously different context, but just to say, and that's not a joke. I mean, that's unfortunately a very sad reality, and I'm not saying it happens all the time, but it's just to me a really symptomatic an example and a symptoms of what we are seeing in terms of quality of the substance of it. Then in terms of the process, of course, I already allude to governance and accountability issues, including risk of corruption, conflict of interest. We talked about revolving doors, but again, I also mentioned also not a monopoly, but a very kind of very narrow area or market, let's say, with major consulting firms that really have a huge power and influence in that case, and that is not a really great. It's not really great news for human rights protection in that sense, as you all can imagine. So I'm not expanding on that. I will turn now because in our contribution we look not only at this, obviously this one issue, but I want to say, but also on what happens on special economic zones and other types of projects in Cambodia, Laos, Myanmar, Thailand, etc. So I just encourage people who are interested to look into our submission. But just to also, before I go into good practices or better practices, to end my intervention, I just wanted to respond, or as you said, it resonated very much what Astrid, the special rapporteur, said. You mentioned the lack or the need to better reflect climate concerns in impact assessment, environmental impact assessment. And I think in the El Kimbo project, for instance, we noticed that there were massive issues with carbon emissions in that way, and it was sold as a green energy project, obviously with carbon market credits, and this was nowhere really reflected in the impact assessment. So, and I don't think, of course, this is a slightly older case, but I don't think things have changed so dramatically, and I think this is really a big area where it has to improve in terms of good practices, because despite or in addition to all I said on the fact that it's more of a ticking the box exercise, that often administrative courts, by the way, have to deal with claims on impact assessment, which makes it very difficult to have effective remedy and to the level that should be considered, but also it can be just washed away by a presidential decree, as it was in that case, for instance. So again, major rule of law and legality issues, but there are also a massive issue of public participation, as I slightly mentioned. But we see that in a lot of contexts where people are not really consulted or even able, because information as well is very difficult to access. So in terms of good practices, I think we have several examples that we mentioned in our contribution to under the call for input, including in terms of how the institutional framework to receive this impact assessment and assess these assessments and see if you can go ahead with a project, including in Australia, where there are good provisions to ensure that there will be sufficient independence, including from independence from other entities and branches of government, for the integrity of the work of such environmental authorities, and budget autonomy, etc. Netherlands as well. And all of these, and also in Latin American countries, some encouraging trends to have better procedures in particular for the institutions that have to deal with, and hopefully it will give also a framework that is just more conducive to meaningful public participation. And that is not only a ticking the box exercise, as was mentioned several times. I finish with, in response to something that the special rapporteur said, I think if you are looking at developing maybe tools to guide, as you said, institutions, how do we do that for states? We need to take a bit more of this decision-making power. And I think there is potentially inspiration in the work of the special rapporteur on water, Leo Heller, at the time, on how do you, like a step-by-step assessment before you jump into, so to say, sorry for the but into an hydroelectrical projects. So I think there is a lot of inspiration there. Thank you so much.
Thank you very much, Sandra, for this really thorough analysis of the situation. And as you said, we can go back to the contribution of the ICJ to this discussion in the preparation of the report. I think I said that what the special rapporteur ended on is something that resonated to you. I think what you said, Sandra, probably resonates a lot to Yukti Shudari, who's joining us directly from the northern part of India. Thank you very much, Yukti, for being with us. You do have quite an experience in the field in dealing with this question of environmental impact assessments. And I think if I'm not wrong, one of the issues you do have in the field is precisely some kind of an exclusion of or difficulties to include the real social aspects, which is supposed also to be part of the environmental impact assessment, or as it was said before, could be perhaps some kind of a trick. You pretend you put the social issues in the environmental impact assessment, but that's one way not to take it into consideration. But please correct me if I'm wrong. And once again, thank you very much for joining us directly from the field, if I can put it like that, from the northern part of India. Yukti, the floor is yours. Thank you very much.
Thank you so much. So I have a brief presentation today, just to kind of help with everything, to make things more clear. So I'll move on to can you second slide, please? Yeah, so before I move on further, just to kind of give you a little background, India is relatively a younger country which has actually adopted an environmental impact assessment. So we formally had a very rudimentary system, so-called EIA, only in 1994. India was more like a closed economy before that. Only it was in 1991 when we actually, it opened up and everything. And it was actually in 2006 when we had a proper EIA notification, which deals with which sector, which EIA, how the EIA has to be done, the scoping exercise, the public consultation, and the appraisal process, everything actually elaborated properly. So one of the biggest things that I would like to mark out before starting out and discussing anything further is that just excuse me for this, is the fact that we just have had 20 years of experience, and because of that there are a lot of things that in India specifically is we we have a lot of challenges in hand, and there are a lot of things that need to be done. I personally feel that public consultation and appraisal are the most important part of the um, environmental impact assessment. And public consultation includes two processes. One is the public hearing, and the second is the written objections, if any. So, public hearing is the one where you have the entire community or the impacted people gather together, and they get together in a place which is usually, and before that, information about the project is told to everybody, and it is in a vernacular as well as in English, put up on a website. So it is presumed that people will understand the technicalities as well as the social issues, everything related to all the like Sandra just mentioned, she spoke about these companies which come in, the consultants who talk about they plan out all the, uh, the technical parts of it, which actually the layman might not actually understand, but that is what is put up in the field. But now going ahead, there are a lot of challenges. I want to put these challenges out to all of you before. Can I go on this fourth slide? So I no, next one, please. Yeah. So one of the things that I really want to stress about is the social and cultural impacts of which are often under assessed. Now, technically, in an EIA, in the Indian context, the EIA is a part of the um, in the public hearing, the social impact assessment. It's a part of it because they try to get input from the people. But what has actually happened is that a lot of times the ecological environment and the society have a very symbiotic relationship. But what has ended up happening is that when that EIA actually happens, it has tended to overlook the process. Now, to just give you an example, I hail from Rajasthan, so that's in the desert area. So there is a tree by the name of khejari. That is a drought resistant plant. It's a very sacred, and when we build a house or anything, when we have a puja or anything, the first thing we do is that we light a lamp near it. Our temple is always near that tree. The leaves of the plant are used. uh, the pods, everything of that plant is used. The cultural practices are very closely interrelated in that aspect. But the EIA is very limited. It has not absorbed these traditional practices and incorporated them within the process. The formal process is not in recognizing the traditional practices, the traditional knowledge, the livelihood systems. So to give you a very recent example, the Jindal mega plant um, um, plant which is going on in Odisha. I don't know. I'm sure you are aware of it because very recently there were 8 special rapporteurs. They've issued a letter to the Indian government raising concerns over this project. But what has happened is that there's a fishing community here, and I happened to speak to them personally. There is a village called Nolia Sahi. In this village, 98% of the people are related to fishing, either directly or indirectly, to an extent that they do not buy their boats. They make their boats. It's an art that is handed down to them generation after generation. But this aspect has been entirely overlooked when the environment clearance was granted. Nobody listened to them. Nobody knows that there is even this, that one of these villages which is entirely dependent on fishing, and once this project comes up, they are going to be all unemployed, and they do not have the necessary skills to actually move on and do anything else. So, like the special rapporteur just mentioned, you can see a very clear exclusion of the social aspect in the environmental impact assessment. So, what it is claimed that the entire environment impact assessment is including a public hearing which will address the social impact assessment as well, but that is actually not happening. Can you go to the next slide, please? The second aspect is the intersectional dimension of the public hearing. I have I happened to read the report, and there were talks of women, children, indigenous population, and I really appreciated that part, that at least that was brought up in the report. But India is very different. India is a country where it's just not gender. We have the gender dynamics, the class dynamics, race, caste. I think my slide has actually forgotten race. We even that also should have been here. The power imbalance. So when all of them come in together, it's not a it's a very difficult situation. So, for example, what actually happens is how public hearing is held, which I would call it to be the heart of the entire impact assessment process, the public hearing. It is usually held in the probably right in the middle of the village, and usually in the middle of the village is also where we have our temples. So it is generally somewhere near what I would call like the sacred space. So you would see a lot of Dalits may actually not be allowed to be around that area. A lot of times it's just an all men gathering. It would be headed by a SDM or a DC, and these senior officials are usually males coming from privileged backgrounds, and so the gender dynamics get very, very pronounced here. I have personally heard of cases, I know of cases where women from lower castes were made to sit in a corner and told to just that, you sit in a corner, and when you go, you put your thumbprint, and in exchange, we'll probably give you, like, when you go, like a laddu and a banana and a samosa. That's like a small snack out here. And that is the value of their, it's more like a tokenism, more like a manipulative way to kind of get what a project proponent would want. So if they supposing they want to acquire the land, there's no real consent. The free, prior, informed consent, that's not coming in. It's really a case of manipulative consent. So this intersectional dimensions, what it really creates is the male upper caste, uh, along with the privileged people, actually deciding the development trajectory of a geography. Then the third question that I would like to address is the can I go to the next slide? Yeah. So the regulatory changes through administrative instruments. So one of the issues in India which is now becoming a big major challenge is the increasing reliance on an office memorandum. Technically, an office memorandum is an internal communication, and it evades all kind of scrutiny through any kind of discussions, or any kind of the way a normal amendment would. And because of this, a lot of things have happened internally which people do not even know about. So, for example, from the period of 2006 to 2023, there were only 70 of these. And then from 2023, I think, I'm so sorry, I think there's an error here in the slide. Then it increased to 323, and some of the really some of the these office memorandums have been extremely violative of the basic essence of an environment assessment. So one of them was a star rating system. So the star rating system, through this, the central government decided that we need to increase the efficiency of the environmental um, agencies, because they are probably really delaying the process of development. So they said that, well, we are going to give each state authority which appraises the procedure, that we are going to start giving them points for the work that they do. So if you manage to finish off the entire process within 80 days, you get 2 points, and if you do not manage to do it within 120 days also, then you get 0 points. So it essentially became a race, and nobody was actually appraising the documents properly. There's a lack of manpower which is recognized. I have personally met with an expert member of the National Green Tribunal, and he told me that one of the biggest problems that our country is facing is the fact that it's not that we do not, firstly, we are understaffed, of course, and there's a limited there are limited resources, and secondly, it is not technical know-how which we are missing on, but it is the fact that we do not know who is really appraising your file. So like in India, the officials, they are all selected from this really sort after exam known as the UPSC. It conducts these exams, and you have the IAS officers and other officers. So there is no a technical criteria, that you don't know whether it's a doctor who's going to be reading those documents, like Sandra just mentioned, or is it going to be an engineer who's going to be reading those? Is it going to be a lawyer who's going to be reading that? And there have been cases that there that things have gone out of hand. And then the other case that I would like to highlight is that of the ex post facto clearance. And this is really important because very, very recently, what happened was that uh, I think the special rapporteur did mention that any um, any environment clearance that has to come in, it has to be prior to the implementation of a project. So through I'll just take 2 more minutes and I'll be done.
Yeah, I was going to ask you because I see that you do have a number of other slides. They are very interesting. Just to say that all of your slides will be available on the website afterwards of this discussion. So you didn't do them for nothing. I know you were unable to comment them, but we will keep them. And anyway, we'll come back to this discussion. But please just get to your final point, because we still have one speaker to who we're going to give the floor before we have to end in about 12, 15 minutes.
12 to 15 minutes, true. So the ex post facto clearances, actually, through an office memorandum, what the government did was that they gave permissions to the projects to actually begin. They began to be implemented, and then they could apply for a environment clearance later on after they began. So this was initially, when it was appealed, there was an NGO called Vanashakti which appealed against it. And the Supreme Court said, well, yes, true, it's actually against the precautionary principle. And then in November, the Supreme Court itself reversed its own um, judgment and said, no, it's okay if there's a lot of money involved, and we need to see to that as well. Maybe with penalties we can figure out things. And so as of right now, the status is that ex post facto clearances do exist, and they are allowed in the country to some extent, and this is not a very good news. So I'll stop at that. Thank you for giving me the time.
Thank you very much, Yukti. It was really so great to have all of these elements coming directly from the field in what you are confronted to in India. So this is really great to have all of these examples. Again, thank you really very much. We will come back to you. We'll come back to this. This is really opening a discussion. The report was presented last October. We didn't have any opportunity yet to start to work on it. This is the very first time we're doing it. As this is an event which is done on the side of the council, we have to limit the different talks. The special rapporteur have to rush to another meeting afterwards, so we can't have anything which is longer. But you've proven, and we knew that, but you just proven how much we need now to go more in depth in these different elements. And so thank you again, really, for all what you're bringing in. And as I say, this is just the start of the discussion. Now, there's another aspect also which needs to be covered is you also have issues of impact, human rights impacts and environmental impacts in in trade agreements, in international agreements. How much do they have such an impact? We see now, for example, also in national systems, how they are requiring, for example, economic impact assessments. When you take decisions, you have to do an economic impact, but they forget that you also need other type of impact assessments. And of course, trade agreements played a huge role, have a huge impact in this. So Caroline, we're really very happy to have you with us. You're one of the specialists of this field. You have just produced with the Prioritization this document I can present here. Okay, it's on your side. The camera is on your side. We can see here the document. There will be a link also to have from the webpage. There will be a link to have access directly to this document, which has been produced with the Prioritization. So, Caroline, what is your take on this issue after the report we had with the special rapporteur?
Yeah, well, interesting, and really welcome this report. I think it's really useful and really help us move, forwards. I think there are different, as the presentations have illustrated, there are different approaches, and it's good that we're in touch and can think about how to move forwards together. For me, it's a particular pleasure to be here because usually I'm the sole human rights voice in an audience of usually trade policymakers, if not economic policymakers. So you can imagine that's a much more lonely space than being here today. And so, as I think it was mentioned, my experience with impact assessment is really the trade policy field. So it's really about policies. And I've carried out 4 impact assessments and often comment or critique others. And recently with Martin Brown, published this sort of how-to guide that we hope will be useful for the trade impact assessments, but perhaps more broadly also. And so again, I think a lot of the points in your report really resonated with me. I mean, I sort of, tempted to sort of give umpteen anecdotes about, I can give an example of when that happened, but I won't take time for that because basically it's just to echo the sort of basic points you made. So what I want to do, I want to make sort of 3 observations based on your report and then set out a challenge, or sort of a double challenge really. So the first observation is this issue about how states ignore their human rights obligations. And you mentioned, I think, various, the legal basis for the obligation to carry out impact assessment. For me, it's right there. I mean, it's there in various, human rights treaties, and I think set out most clearly in General Comment 1 and perhaps General Comment 3 of the Committee on Economic, Social and Cultural Rights and other places since. But, just very simply, how can you propose a policy or move ahead if you don't even know, who it's going to serve? And this is general across economic policy, and I think there's a real role that we can play in, sort of challenging this narrative, which I'll come back to later. So you said in the report, I think this is the only point on which I slightly have a different take from you, but hopefully we can discuss it.
Welcome.
You say that states have a permanent obligation to evaluate the activities and projects, which I agree with completely, and I would say full stop. Because I think you go on to say to evaluate activities and projects that may cause human rights violations or significant harm. I'd say, how are you going to know if there's harm? And maybe this is, in environmental cases, perhaps it's more evident, but in terms of sort of social inequalities or perpetuate, okay, well, maybe, anyway, but suddenly, in other areas, you don't really even know until you've actually sat down and thought through, what might be the impact of a particular policy change. So I would, so that I would put the full stop, before the end of the sentence there. I'd say that there is a permanent obligation, rooted in law. We know, I don't need to describe which sources of law for this audience. And I think so ignored. I mean, I won't go into it, but I've worked a lot in Switzerland. There was a whole issue about, Switzerland, Swiss government was saying, we're not going to do human rights, so we're not going to do impact assessments of trade agreements because we don't need to. And we're like, coming back and back and back and saying you have to. And then yeah, so we know the difficulty of that. Switzerland has then moved, but then the actual implementation is complicated. But one of the difficulties, and this is a point I'll come back to in the challenge at the end, is that one of the things, so as part of this process in Switzerland, we said, no, you have to do this. And like, oh, no, we don't. And they're like, oh, maybe anyway, sort of like back and forth for years and years and years. The Swiss government commissioned OECD to write a report on impact assessment of trade agreements. And they treated the three separately. So sustainability impact assessment, environmental impact assessment, human rights impact assessment, and the bit on human rights. I mean, I don't know if it will make your hair stand on end. It just so completely misunderstands and misrepresents, the approach. And you get into these kind of sterile discussions about, can we model quantitatively whether this trade agreement is actually going to result in more cases of torture? It's like completely, okay, right.
It's actually there.
Well, I mean, yes, it has, and I think that having been said, I think it's progressing. But I think so this comes to my second point. I also wanted to make about how in the trade that the EU is quite is I think the only sort of economic entity or country, group of countries that systematically carries out ex ante impact assessment of its trade agreements. But if you look at the title of them, it'll say sustainability impact assessment in support of the trade agreement with whatever country. And so it's like, I mean, again, your point, right? It's like kind of the title sort of prejudges what it's not a question. And then typically they're presented and the commission will say, oh, yes, great. You've pointed out some things, but we've dealt with them, so it's all okay. So my second point is the usefulness of a human rights based approach. So the impact assessment of trade. So my point, and this is something where, and I think it was sort of a process for me and sort of like figuring this out, but where I stand now, my personal position is that a human rights approach to impact assessment should inform any kind of impact assessment. So whether you're looking at environmental impacts or gendered impacts or social impacts or or economic impacts, the human rights methodology will also direct the intention to where it needs to go. And I think there's another thing that we struggled with in terms of communicating, and maybe this doesn't play out so much in environmental impact assessments, but trade agreements now, as you know, cover a huge range, digital data regulation, investment, agriculture, I mean, all the kind of things that could be traded, plus a whole load of regulatory areas. So, you can't, I mean, I think it's pointless to try and do impact assessment of all the agreements. So I think that's where the human rights approach can really help us, because we start off by looking at who's most vulnerable and with a participatory process, and then you can identify like 2 or 3 groups. And in a particular case, you sort of gave some examples. In a particular case, it might be women. In some cases, it might be an indigenous, or it might be a particular region where there may be sort of these intersecting, vulnerabilities. And it really directs attention to the kind of issues or topics or impacts that economic analysis often overlooks. Because what we do see, and quite often, I think this is the case for also the EU. I mean, almost all what they call sustainability impact assessments of trade agreements tend to start by like doing the economic modeling and say, okay, the biggest sector or the sector that's likely to grow most is, automobile parts, exports. So we'll focus on that. And the human rights approach says, no, we don't care about numbers. We look at where the most, and that is the sort of non-discrimination, the substantive equality, human rights approach. And then it doesn't, and it comes to another point where, again, I'd love to discuss with you. You're talking about changing the terminology to environmental, what would you say, environmental, social human rights. And in the trade, I tend to look in the trade field, we talk about sustainability impact assessments, but I say that within that, you've got biodiversity, you've got human rights, you've got women's rights, you've got environment. And again, if you use the human rights approach, it'll direct, maybe, to which particular topic or particular area of concern. So that's a question of terminology. I think it would be interesting to maybe think about what's the most useful terminology across. But I'm not too bothered about what, but I just think from a strategic point of view, it might be a question we want to discuss further. I also think that the human rights approach directs attention to these market and non-market forces. And Yukti, you gave a really good example on that. I work a lot on feminist approaches to economics, where we talk about a lot about this sort of the how we give a lot of attention to the market sphere, but we ignore the non-market sphere, and that it is ecosystem services, it is the traditions, it's the cultures, it's these things that can't be quantified. And I think there again, human rights has a real role to point out the importance of that. Intrinsically from a human rights principles perspective, right? But also perhaps instrumentally by saying, if we don't maintain these things, if we don't maintain ecosystems, if we don't, maintain, diversity, it's going to have knock-on effects down the road. I think a human rights approach also something that's often critiqued in impact assessment is why are you assessing this sector and not that sector? If I was going to do impact assessment of a trade agreement and I look at intellectual property or medicines, then the sort of the pro free trade people might be like, oh, you looked at that sector because that's one where you can expose a problem, and you didn't look at the other sector where it might be really fantastic in the results. But I think again, a rigorous human rights approach, you can say it's an objective way to say, well, we chose this sector because this is where from the processes, the toolbox it offers, direct our attention there. It's not because I'm captured by this interest or another. So okay. And then the other thing is that human rights are misunderstood. I gave the example of the OECD situation, and this issue of quantitative, qualitative approaches, market, non-market. And I think so. That moving to my challenges, I think we have a job as a human rights community to better communicate what human rights are and what it means in this context. And I think perhaps in these areas, perhaps it's more well known, but in the macroeconomic policy area, we've still got a long way to go to avoid these discussions about what does macroeconomic policy result in more, people in prison without trial, which is not the key question in this context. But I also think to communicate better what human rights are and how it can be applied, but also to engage better. I think there is a literacy, and just my final point is just when I've been trying to do a human rights impact assessments of trade policy, I try to talk to people who are working on in the health area or indigenous groups or women's groups and say, what do you think this will change or what has changed? And quite often the immediate response is, oh, I don't know anything about trade. I won't come to that meeting because I don't understand. And then you talk to the trade people and say it's a human rights impact assessment. They say, oh, I don't know anything about human rights. And so there is this, beyond the availability of information, which is problematic in many ways, there is this simply lack of understanding. And again, sort of echoing a little bit what Yukti said, I think this is a way that we can recapture the narrative to say that that economists are very good at making you feel silly if you don't know about
my
quantitative.
sister is an economist. Big existing.
And so if they're making you feel very silly if you can't engage with the issue of quantitative modeling. So I think that again, we can, and these environmental impact assessments that you focused your report on are ultimately about economic policy choices, aren't they? About what counts, what doesn't count, where do we, this idea that, well, no, if we don't build this dam in this place, and yes, some people are going to use their lands and their traditions, but if we don't do it, our country is going to never develop. These kind of narratives, I think there's a real role for the human rights community to play, they've already started, but to play more of, to really challenge this dominant economic thinking. So thanks a lot, and I look forward to continuing the discussion, probably informally at some other time, but.
Thank you very much, Caroline. And I think the last word with which you concluded your presentation are really the very good ones. Indeed, it's interesting to see how these type of impact assessments can help us to deal with some of what we had already identified in the previous talk about the main drivers to which we have to address. Otherwise, we remain outside of the real impact precisely. So I think, well, thank you very much to all of the speakers. I do hope there's a technical aspect to this discussion, but I do hope that it didn't make anybody feel silly. We're not economists, so we hope we don't have this impact. But I think really the wealth of the information we had and all of these remarks show how much we do need to continue this discussion. Your report is triggering something, and we will continue to build on this. So we're really happy to have this very first opportunity to work on this. I think this gives us a lot of elements to see how we should continue this process. I've noted how we need to, identify better the different basic process. So there's a view of what these process really should be, like a very clear model. The legal framework, we didn't have the time to talk about the Aarhus Convention or the Escazú Agreement, which are providing specific legal obligation to states, and we need to use this much better. And there's also, which came from Yukti, something which is really very important is the context in which this applies, because you don't only have the norms, but you need to understand the context. When we talk about vulnerable people, for example, or the most vulnerable in different situations, who do we mean exactly? I'm thinking of issues we had, for example, in Europe, where we were linking to a Roma people, and the authorities thought they had dealt with it in a very, very good way, very sincere way, but they didn't at all, because there was no procedure that was really helping. So what Yukti was saying was really very much resonating to that. So the context also is extremely important. So there's a lot of work to be developed on this, because these instruments are being used. They do have an influence, and so we have now to put our hands back on this so much it's needed. So if you want one final word, Special Rapporteur, and we'll conclude
Maybe
on
10.
this.
Yes, exactly.
No,
just
one.
to say-
We don't have time for
Thank
10. You have to rush to your next meeting.
Yeah, no, just to mention, so thank you very much. And of course, the idea for the report is to contribute to the conversation, and we can disagree in pretty much everything. That's perfectly fine, but just to try to link this. And the last thing that I will say that is very important is that the next report that I'm preparing now is on, and it's also for the General Assembly, is on planning tools. So the way that I thought about it is that EIAs or EIAs is the project and activities, and then we have to go the next step to think about planning. So the call for input is open. So if you have sent them, thank you very much. If not, please send them. The deadline is this month, so you still have 20 days to send them. And if you need more time, let me know. But the idea is precisely that, because we can't solve everything in the project by project. We have to go and have a good plan. I don't know how 10 words, but thank you.
Thank you so much. Really, once again, thank you to all of the contributors. Thank you for all the people who have attended this
Yeah, thank you
meeting.
very much for-
You will be able to find, to replay this and to find also more comments and resources on the webpage of the Geneva Environmental Network. And for this, I give the final word to Diana, with once again thanking her and her team for making this possible.
I just want to give you an appointment for the next events. We will be now joining the Ciel event that will also be streamed online. That is not on this slide, but we are back here in this room at 3:15 to discuss human rights in the Convention on Biological Diversity at the upcoming UN Biodiversity Summit that will take place in Armenia later this year. So we look forward to see you on those occasions. Thank you.
Thank you very much.
And we run to the
And we run to room 8. Room 9.
room 9.
8, you might be making an intervention in another meeting.